right? She wants the restaurant to look a certain way. She wants it to, appear not like a pool hall, but like a restaurant. So she makes various changes without his permission. So this is a classic sort of dispute. Now, which way was I going? So, Kaylee, let me ask you this question. Fast forward a bit. What happened shortly after Mrs. What's her name? The restaurant owner is evicted. What happened shortly thereafter to the restaurant? He rented it to someone else pretty quickly, right? Didn't he? What do you find suspicious about that? Find anything suspicious about that? Yeah. So what do you think prompted this sudden concern about these health conditions? Everyone see what she just said, right? This isn't in the case, and I have no idea if I'm actually right about this, but I'm willing to take an educated guess that he rented it out so quickly for a commercial property. He probably had someone waiting, and he was like, wait a minute. She's, making these renovations, right? She's, health violations. I could just shut her out and bring my new guy in.
This may be done, but isn't he under an obligation to get his loss, so that's appropriate? Well,
I see what you're saying. So if indeed Mrs. I keep forgetting the names, Ms. Berg, I always invert the names, Ms. Berg surrendered, right? If indeed Ms. Berg had surrendered, he would then be under a duty to mitigate. But what I'm saying is different. He wanted to toss Ms. Berg out in order to bring in maybe a higher paying tenant, as Kaylee said a moment ago. That makes sense?
Yeah, no, I see this.
Yeah, this isn't a case where he was trying to mitigate it. He was trying to get rid of her to make more money. Okay? So, that's not in the facts, but I'd be willing to wager that's what happened here. That was what was going on. So, in June of '73, Wiley says, you're violating health codes, right? And you're making renovations without my permission. And he gave her 8 remodeling demands to complete it in 2 weeks, or else he would retake possession. So Anna, do you think it was feasible, or do you think he even intended that it was possible for that 2 weeks to be sufficient to make all these various changes? What do you think he was trying to do here? He was trying to give her, he was trying to kick her out. So he said, okay, look, I'll give you 2 weeks to make all these changes and bring everything into compliance with the health code. Query, is he even allowed to evict someone for violating the health code? The case didn't really resolve that, but it's actually a difficult question if that's not a term of the lease. But he said, listen, you got 2 weeks, right? So Berg never actually closed her restaurant. And at the end of the 2 weeks, she fired off all of her employees. And they put a sign on the door saying closed for remodeling, right? Christian, what does the sign for closed for remodeling actually mean in this context? What do you think was actually going on here? She put this, fired all of her employees on a Friday night, and then put the sign closed for renovations. What do you think that sign actually meant?
I'm not sure.
Oh, come on. Do you think she was actually closing for renovations?
No, but
so actually, contemporary example. Everyone know the 59 Diner?
Yeah.
It's right by Shepherd near 59. That's what I think it's where it's named from. It's still closed, right?
Yes.
So about a month ago, they fired all their employees and put up a sign that says closed for remodeling. Is that right? They're still closed. So this is a common tip of restaurants to try and say, oh, we're not vacating, we're just closed for remodeling. So I think it's safe to, for whatever reason, the court maybe is as trusting as Christian is. I'm not so trusting. The court said, well, maybe she was going to do the renovations, right? Maybe she would. But I think it's a pretty safe bet that she was going to cut her losses and walk away from the building, right? She had these health code violations. She had to make all these expensive changes, right? You don't fire all of your employees if you're actually remodeling. Yeah, Jessica.
But it also seemed that it was such a short time that the landlord had given her to come up into compliance with that all the observations.
Well,
It's not only 2 weeks.
He had complained about it before, didn't he?
Yeah, well, apparently there was a very antagonistic relationship that came from
Yeah. So I think Jessica raises a very fair point. They hated each other, right? They hated each other, And I'm almost positive, again, the facts aren't entirely clear, but he was probably complaining about these things for a very long time. He said, you know what? You got 2 weeks to finish it. And she was like, I'm going home. I'm just gonna walk away. She probably thought it'd be cheaper to walk away from the business than to have to pay for all these various health code violations and things. But if I had to guess, again, the facts here aren't entirely clear, but she probably knew she wasn't supposed to be doing this very early on. Or maybe, if indeed this was antagonistic, you can be sure the boss, the landlord, was telling her, fix this, and she was ignoring it. Maybe, I don't know. But in any event, this was only 1973. Christian, when did their lease run up? When did the lease was closing to end? How long was it?
1st, 1975.
Yes, sir. So there's still about, a year and a half left on the lease. Right? There's still like almost about 2 years left on the lease. So in theory, at least, she still had time to bring herself into compliance, right? This 2-week deadline, which was totally unrealistic, was arbitrary. She still had 2 years left in which she could make whatever renovations are necessary, right? The landlord can't decide suddenly, okay, 2 weeks from today, that's it. Then you lose, okay? But he said that. So what, Ashley, what could the landlord have done short of hanging off the awning or whatever else? What could he have done perhaps a little bit more, less antagonistic, shall we say? What could he have done?
Rather than negotiate.
Yeah, what were the other options for the landlord?
I'm not sure since she got 2 years left.
Well, what happens if a tenant violates his or her lease?
Well, I guess she violated her lease.
How?
File a suit.
Go to court, right? If indeed the term of the lease said you need written permission to make renovations, and she didn't seek written permission, that's what we call a breach. You breached your lease. Has anyone ever been evicted? I shouldn't ask that question. I asked that once. Someone raised their hand. I should have asked. So I'm not going to ask that question again. So never mind. But she breached her lease. She violated the term. So he could have gone to court. Now, Brent, why do you think he didn't go to court? Why do you think he did this entire, Spider-Man deal?
He just wanted to get it done with.
He wanted to get her out quick to bring in the new tenant, right? At common law, there's modern stuff, but at common law, what's called the ejection or eviction process is very time-consuming. It could take months, especially in a commercial, because then they would have to go to court and they'd have to introduce evidence. And you say, wait a minute, no, I didn't make these renovations, or these renovations are consistent and these aren't serious renovations. There are all these evidentiary and factual disputes that would come up at a trial. So he's like, okay, you know what? I'm not going to go through the court system. I will engage in self-help. Did you guys study towards self-help? This concept? The use example is self-defense. If someone's on your property, you can shoot them. The law historically recognized various forms of self-help. And in property, one of the aspects of self-help was if someone's on your property and they're not supposed to be there, you can use self-help to remove them. What does that entail? Changing the locks, selling their stuff in order to cover any back rent. We'll talk about security deposits next week, but you can withhold the security deposit and not pay it back. Right? These were all elements that were available to a landlord at common law to deal with a holdover tenant. So, so in this case, Caitlin, we have a pretty funny set of facts. Can you just walk us through what happened after the landlord decided to kick out his tenant? Like, what was this confrontation that went down?
He waited until she was gone, and then he changed the locks.
Yeah. Well, but before that, what happened before he changed the locks?
Spied on her.
He was spying on her, right? Why did he claim he was spying on her? What did he think was going on there? It's funny, right? He thought, maybe she was, who knows, but he thought that she was removing this is the 1970s, wood paneling, right? That was the big thing, right? The landlord thought that the tenant was ripping wood paneling off the wall. And I think we've discussed this, but stuff that's affixed to a wall is called a fixture, right? When you move, you can't remove like a bookshelf built into the wall. So the dude is literally, how do you hang off an awning? I'm trying to just imagine. It's like, are awnings that strong to support a person's weight? Yeah, it's creepy. And I'm thinking like he's hanging by his feet like a bat, like, you know, looking in or something. Like his buddy's holding his ankles. Like I'm trying to figure out what the hell this is. Because if he's hanging on the awning, you have to look down. I need a diagram or something. I don't know how this works. But dude's hanging off the awning, looking into the apartment, looking into the restaurant. Is like, oh, they're stealing stuff. So then, Berg calls the sheriff, you know, the local sheriff, who I guess she was, you know, close with. And then Wiley calls the city police. You know, maybe it's the big police, and the cops like, oh, I don't want to deal with this crap. So they say, listen, let's maintain a peace status quo until Monday. You guys can talk to your lawyers on Monday. This is on a Friday, and like in second, and it said, look, just come back on a Monday. Like, don't do anything stupid for the weekend. Yeah, Pierce.
In a commercial lease, could a landlord put in the actual lease that he has a right to come in when he wants to? Because it seems like that would have remedied a lot of this, like.
Well, come in for what purpose?
Like basically just like have a right to come in.
I think this lease had such provision. I think this lease said if there's a breach, the landlord can re-enter.
Right.
What the court basically holds is that's contrary to public policy.
Right, but he's banging on the back door saying, let me in. So clearly he did not have a key to come in. He couldn't he had to come in with them actually letting him in. Maybe she changed the locks. No. I mean, actually, no one's ever asked me that question, but it's possible that she may have put a padlock on or something. Or she may have put an additional, you know, deadbolt or something. I mean, she could have just deadbolted it from the inside. Yeah. Even if you had a key, you can't get by a deadbolt. Right. I don't know. I mean, none of this is, the facts in this case are unfortunately very sparse, but I suspect, or let me put it this way. Imagine, Pierce, for a second, what would have happened if he had a key. And like, you can imagine Berg's in there talking with friends like, oh man, this business, what are we gonna do? What are we gonna do? And dude walks in, he stands right there, he's like, all right, guys, get out. What do you think would have happened? Probably would have been in a fight.
They would have gotten into a fight. So maybe he thought it would be a little bit too confrontational to barge in. That's why he was not. Yeah. Right? I think Norma mentioned something last week that, like, you know, she tried to move into a house and like there was almost fists, and then she called the cops, right? Yeah. So you can imagine that maybe he was trying to avoid. I mean, maybe the buddy holding by his ankles off the awning, right, would have come and given him some backup, but who knows? So, in any event, cops said keep status quo till Monday. Okay, fine. Monday, Wiley walks in there. Berg. I don't know why Berg wasn't there. If I'm Berg, I'm going to be in that property all day. I'm not going to like even wait a minute. So she, I don't know, went out somewhere, whatever. Wiley calls a locksmith. Locksmith comes in, picks the lock, and then changes the lock and locks out the restaurant owner, and she can't get into her property. So at this juncture, I'm sorry, then about a month later, not even a month later, he locked her out on July 16th, and then August 1st, the new tenant comes in. So we're talking like 2 weeks. So there was almost certainly a tenant waiting in the wings, and they just started for the first of next month. So that's why I suspect that they were holding it for someone else, but you know, I don't know for sure. Okay, so Jackie. So what happens in court? Who sues whom here? Mm-hmm. Yes, IED, our favorite, right?
And he also
Okay, good. So most of these claims are tossed out. I don't care about IED. Go to torch for that. I couldn't care less. But the major cause of damage she's seeking is for wrongful eviction and lost profits, right? Jackie, why is she claiming lost profits? What's like the basis of that claim? Yeah, her business is closed, right? She's saying, look, I had another, 2 years left on the lease. I made X dollars per month on average. Project that out. Here's how much money I would have made over the course of the lease for my business. Now, of course, we know her business had massive health code violations, and there's a substantial chance she would not have made that much money, but she said that's how much money would have made. And she also brought a cause of action for wrongful eviction. This is like a tort/property cause of action, but basically saying the law did not permit you to forcibly remove me from my premise because I still had a legal right to be there until a court says otherwise. So the issue in this case focuses on this idea of self-help and whether a landlord is able to avail himself of this technique. So Ross, tell me, under the common law, were landlords allowed to use self-help to kick out a tenant? What were the restrictions on how a landlord at common law could use self-help? What was like at least in Minnesota, the restrictions they imposed upon it? Peaceable. Okay, so let's take that one part. I'm going to do peaceable first. Ross, what would a peaceable way of kicking someone out look like? Okay, so what would a way of kicking someone out that would not involve confrontation look like? No, but we're talking self-help here. The entire point is no courts are involved. So what would a peaceable, non-forceful way of kicking someone out of their house look like, or business, whatever it is? Yeah. Tim, you want to take a stab?
Don't pry open the lock and you ask them to leave.
Okay, so you ask them to leave and they say no, which most people, I'm assuming, right? If your landlord says get out, you're like, screw that, no. Then what?
Theoretically, you could change the locks.
Okay, so that was the answer I was thinking about, right? Now, Tim, is changing the locks on someone peaceful?
Yeah, it's peaceful, but still forcible. You have to change the lock.
Okay. So, this is a tension that I can't quite see. I've been teaching this case for a number of years. I don't know a non-confrontational way to evict someone, right? It's a very personable decision, right? Where you live, your house, your family's there, your clothes, your people are very closely tied to their property. Even if they don't own it, they're a rental. I don't see any way of evicting someone with self-help unless it's forcible. It doesn't mean physically grabbing them and tossing them onto the gutter, but it's still even the act of using this sort of proceeding. Oh, help me out, Pierce. What's a good way of non-forcibly evicting someone? Help me out.
That was the thing I found weird. I actually thought what he did was peaceful. He intentionally waited for her not to be there. He had a police officer to make sure everything remained civil.
Interesting.
And he changed the locks. It's not like he came in with an officer, had her arrested against the wall, changed the locks, and it was all done calmly, peacefully. She basically just walked up and her key didn't work. I don't know how much more peacefully.
And I think Pierce makes a fair point, right? Because if this isn't peaceful, then nothing is, right? If the standard the court puts forward is actually standard, then everything's forcible. Because I kind of agree with him, right? I think he probably, we don't know what time of day he did this. He probably waited till time of day when she wasn't around. He brought the locksmith in. But if this is forcible, then I can't imagine what peaceful is. In any event, it doesn't matter because the court got rid of this entire doctrine, right? The court kind of jumps over that fairly quickly. So the first issue, which I don't want to spend any time on, is whether she abandoned the property. Had she abandoned it, then he would have been okay. There's no evidence that she abandoned it. Just she didn't do it. Okay. So Brian, tell me, sir, how does the court view then this common law doctrine of self-help to help evict tenants who are breaching the lease? For the court, is it ever permissible now for a landlord to use a sort of self-help? Okay, right. So this is, the modern trend, and it's not really a trend. This is basically, I think, in virtually every state, Texas for certain. Self-help is no longer viewed as a legitimate means to deal with a tenant in violation of the breach. Breaching the lease. Okay, it's never permissible. And the court explains that this sort of policy we're trying to discourage people taking the law into their own hands. We have courts. Courts are there for an important reason. So I think we talked here about the forceful aspect. Let's talk about the next aspect. Matthew, can we trust a landlord to make a correct determination of whether a tenant actually violated the lease?
I mean, subjectively.
Give me more than one word.
So I would say no.
Is there a dispute here of whether she was actually violating the lease? Is there a legal dispute?
I believe there is.
And could you, as Ms. Berg's lawyer, go to court and say, no, she wasn't breaching it. She was going to make these renovations, whatever else?
Sure, because you hung up a sign and I'll let you stand on it for that.
All right, good. So here's the point, right? The idea of self-help means that the landlord gets to decide as a matter of law whether the breach has happened. The landlord has an incentive, let's say, to exaggerate breaches or maybe read the lease in a manner favorable to him. The role that a court provides is to say, wait a minute, no. Let's give a neutral judge, both parties have counsel, and they can then argue amongst themselves, did in fact the breach occur? In other words, we're not going to simply take the landlord's say-so of whether the breach has happened. We're going to have an independent judge decide this. Okay? So I think far more than the issue of whether it's forcible or not, 'cause I think Pierce is probably right. This is other than the Spider-Man routine, right? This is pretty tame. This is pretty tame, even though the cops had to get called on a Friday night. It got a little rowdy there. But the bigger issue is the courts want to be the ones to determine if, in fact, the breach has occurred. Okay? Yes, Hunter.
I may be missing something, but I'm not sure how there's an argument about the breach occurring because the landlord gave a 2-week deadline for which the remodeling has actually occurred, and when she puts up the sign, it's after the 2 weeks. Meaning that any remodeling is past the date the landlord said you could actually do the remodeling.
Was that 2-week deadline in the lease, Hunter?
No, it wasn't.
So there's a dispute, right? I mean, I'm sure I don't have the lease in front of me, but it probably says all renovations must be made in a reasonable period, right? Well, it's 2 weeks reasonable to make all those renovations, right? I don't think any commercial lease will say all repairs must be made within 24 hours of written notice, right? That would be insane. There's probably some provision to say, oh, the landlord must give written notice for repairs, and then there's a reasonable period of time to make those renovations. Here, I mean, I don't know what the changes we made, but 2 weeks is probably insufficient. Everyone with me so far?
So the main reason is that it's more equitable, and the subsequent reason is to keep the peace.
I think so, right? I think the entire thing about keeping the peace is probably subsidiary. It sounds better, but I think the real reason is they don't want landlords deciding for themselves whether a legal breach has occurred. Because that, how do I say, the landlord's biased, right? He's going to try, oh man, you breached, you're done. But a judge can say, wait a minute, you can't give her 2 weeks to, put in a new oven and, right, put in new flooring and, repair the electrical. I mean, this is time-consuming stuff. And there are various commercially reasonable standards of how long this stuff takes. Jimmy?
I don't know. It just kind of seems like it's lingering in the background, but the court seems kind of like a policy reason to do this, sort of like kind of forcing the landlord to kind of work it out by forcing them to go to court. You have to choose between a settlement or a court.
Okay, now Jimmy raises a very good point. Justin, let me ask you this question. In the world of the landlord, he just kicks a tenant out and brings a new person in 2 weeks later, right? But what if he knows that he has to go to court and going to court's expensive? How may that affect the approach the landlord takes? Settle. Yeah. If he knows that he needs to go to a judge and not just make an argument for himself, make an argument to a judge that he could lose, he won't be so quick to bring in a new tenant, right? And he may say, all right, fine, I'll give you 2 months instead of 2 weeks. And they try and work it out. Because he knows if he goes to the judge, says, Your Honor, I gave her 2 weeks to fix this thing, judge say, get the hell out of here. What's wrong with you? That's not even feasible to make all these renovations in 2 weeks. So Jimmy's point is well taken. that this regime of this settlement procedure encourages the parties working it out, because you can't be so quick to say, okay, I'm going to kick you out on July 13th, bring this other guy in August 1st, and I'm done with this. The 5-year lease means a 5-year lease, and you can't get rid of this person unless you go through these procedures, right? So, Hunter, you're up next. What then is the procedure in Minnesota, at least, that the court describes to avoid these sorts of confrontational self-help?
You're supposed to go to court and get a determination about the.
Yeah, what do we call this sort of proceeding?
That would be a summary proceeding.
Summary proceeding, yes, sir. What's a summary proceeding?
I believe that is, it's supposed to be a quick and efficient way to resolve disputes between landlords and tenants about a lease or breach of a lease.
Yes, sir. Exactly right. Again, a common law, there's something called an action in ejection or ejectment, whatever you want to call it. This was a very lengthy proceeding to kick someone out. So it's not surprising that, you know, a common law, who wants to go to court, just change the locks and throw away their stuff and sell their furniture. Most states have adopted a expedited process by which landlords can go to court quickly. This is not just a regular court. This is a quick process to ensure that you're not sitting in a situation where the landlord's empty. I'm sorry, the apartment's empty, no one's paying rent, and you can't lend to someone else. So, you know, you have to do this stuff fairly quickly. I'll do the Texas summary proceeding in a minute. So the court in Minnesota adopts this modern rule, and they say that because the landlord didn't go to judicial remedies, as a matter of law, the lockout was illegal. Okay. So any questions on the Wiley case? Any thoughts? Yes, Pierce. You're still thinking this guy was a total gentleman, right?
No, it's about the expedited legal process.
Yes, sir.
They said that sometimes it can actually take about a year and a half.
Yeah. All right. So let me. I'll come back, but I'll walk you through this. So, I have actually up here on the screen the section of the Texas Code which governs evictions and forcible entry. So it's 24.001. This is the forcible entry, and it basically makes it a crime. So if you enter the real property of another without legal authority, you're breaking the law, and that's even if you're the landlord, right? You can't go in there unless you have a purpose. Now, most of your leases, I'm sure, say for maintenance purposes, the landlord can enter to make repairs when you're not there. Have you all? Right, we've all had that in our leases. The difference here is the purpose is maintenance, right? The purpose is to actually repair your apartment and do something good for you. It's a very different story if they're entering your apartment to change the locks on you and sell your stuff. That's a very different story. Section 24.005. I know you can't read that, but I'll summarize it for you. In Texas, in order to begin the eviction process, you're required to give 3 days written notice to the tenant. In other words, on day one, you say, I'm giving you written notice 72 hours in advance before I go to court. Okay. Let's see. Richard, why do you think the law imposes a requirement to give 72 hours notice before you go to court?
So the other person's time to prepare.
Or what else may happen in that 72-hour period?
They may work it out.
They may work it out, or what else? What else may actually happen?
Like pay.
Are landlords always correct when they assert that you didn't pay your rent?
No.
Right. What sometimes happens? People are human, right?
Yeah. Mistakes get corrected.
Mistakes, exactly. Okay, so the 72-hour period serves a few purposes. One of which is the obvious. You send one of those notices to your tenant, it's like, oh crap, okay, I'll get the money. And then like he pays up and then the problem solved. Also, you can imagine a situation where a mistake has been made, right? Let's say the landlord says, you breached the lease because you did X, Y, and Z. And the guy says, no, I didn't. You gave me permission to this. Here's my written statement, right? Here's my lease. And the guy's like, oh, my bad, right? So if he had gone straight to court without any notice, you have to tell that to a judge, and that's a very big deal. Whereas if you go to the guy, I'm like, listen, this is not a breach. He's like, yeah, you're right, my mistake. So if nothing else, this sort of 72-hour notice, or maybe a cooling period, if you will, allows the parties an opportunity to work it out in a hopefully non-confrontational manner. Okay, so you have this 72-hour, it's either 3 days, 72-hour period. Okay, and then you go to court, but it's actually much longer than that. Before the defendant can go to court, you need to actually serve the citation. What does that mean? You have to get the sheriff to, if you've ever seen this, literally post on the door of the unit a notice saying, okay, you are involved in this eviction proceeding. And that can take sometimes between 8 to 10 days, depending, because the sheriff doesn't always do things when you want him to. And even then, you need to give 6 days notice before the hearing. So we're talking, a pretty lengthy process. Okay, so then finally, you have the hearing. It's before a county at law court, which we have them. I'm sorry, the county courts at law. I inverted the words. The county courts at law. At that point, you actually have a hearing. You don't have to be represented by an attorney. It'd be nice if you can, but not everyone can afford it. After the hearing, the judge will give a ruling that same day. The county courts move very quickly, at which point you now have 5 days to appeal the suit. And that's a mandatory 5-day period. Okay, so let's say you appeal, and then the appeals court, rejects your petition, which they usually probably will, unless there's a big legal issue. Even then, it still takes another 2 days because you have to get the constable to post a 24-hour vacate notice. In other words, a day to get it posted, and there's a 24-hour vacation period before the person is actually kicked out. So I saw a couple sources, and as best as I can tell, in Texas, in Harris County, the quickest it can take to evict someone, like the absolute minimum period of time, is about 20 to 23 days. That's like the bare minimum. And that's assuming the person doesn't appeal. That's if everything goes as smoothly as possible. So we're talking about not quite a month, but 20, 23 days. So something approaching a month. Now, Pierce noted that in the book, in other places, it's much longer. In the District of Columbia, the book says it takes about 114 days to evict someone. That's a long period. There's an example from Massachusetts. I can't even fathom this, but 2 years to evict someone. And no doubt this person's not paying rent during the entire time, or whatever it happens to be. In New York City, there's a 3 to 6 month backlog to evict someone. So I want you to, as law students, should always view things on two sides. View it from the landlord's perspective and the tenant's perspective. So from the tenant's perspective, these sorts of summary proceedings have a downside, right? They can be done very quickly. But they also have an upside, is that you have mandatory appeal periods, there's mandatory notice, and you're not getting kicked out of your landlord hanging like Spider-Man. Now, the summary proceedings from the perspective of the landlord, right? So of course it's easier to kick out your tenants in a confrontational manner. But if you can do this non-confrontationally and be done with it in 20 days or so, okay, I mean, you can live with that. You can live with that. Now, if you're in a jurisdiction like Boston or the District of Columbia, and you have to wait 6 months to a year or longer to evict someone, that is problematic. And the reason why that's problematic is you now have an apartment sitting empty for 6 months to 2 years, not generate any rent. So what do you think the landlord does to his other tenants who are paying the rent? Okay, if you learn nothing else from me, everything has a cost. Everything is a cost. Nothing's free, right? If you're letting someone live rent-free under a 2-year eviction process, well, the other tenants in the building will compensate for that, and they'll pay higher rents. Or landlords require larger security deposits, because if they think that it's going to be a 2-year eviction process, they're going to require 2 months rent up front, which won't even cover nearly close enough. Also, landlords impose credit checks. that makes it harder for people without credit to get apartments. These sorts of proceedings have pros and cons, but I want you to be aware of both of them, that everything passes on costs somewhere else. Okay? All right. So any questions on that? Oh, yes, Hunter.
These backlogs, like District of Columbia or New York, does that have to do with an inadequate court system, or is that just having to do with like they set it up so that it takes so long?
So a lot of the backlogs is premised by judges who don't engage in the proceedings as quickly as they ought to. And what I mean by that is if a tenant asks for a month delay, the judge gives it. And the tenant asks for another month delay, the judge gives it. So in a significant number of these cases, the tenant keeps asking for a delay and the courts grant them. Now, the book has a note about this. And they say some people think that these courts are pro-plaintiff. Some think that these are pro-tenant. I don't know the answer, but if the process is that people can seek delays and postpone this thing for 2 years, then something isn't working quite right. But you know, these are decisions that the local legislatures make, and then they appoint judges, and judges make these decisions. So the system is premised in favor of the tenant over the landlord in many respects. Yeah, Jessica?
During the period of time that the eviction process, or the
Summary removal, yeah.
the summary proceedings take, the tenant still have to pay rent, or damage.
Well, not necessarily.
Not rent, but damage. Shouldn't.
No. So Jessica, let me put it like this: what if the reason why the landlord goes to court is because the guy stopped paying rent, the tenant stopped paying rent, and he's not paying rent during this entire time? And if he's there more than 2 months, he's already lost his security deposit, so whatever. So at that point, he's basically living rent-free until he gets kicked out. What's your hand up there?
Yeah, do they just give 1 3-day notice? Are they allowed to give more notices after that?
Well, you don't have to go to court, right? So if the landlord puts a notice and waits 72 hours, the landlord's not required to go to court in the 4th day. He doesn't. He can. He doesn't have to. They have to say, okay, so I'll give you another week to work it out, right? But he at least gave that sort of 3-day notice saying, I can now bring it at any point after this 3rd day. Make sense? Thank you. All right, any other questions in the first case, the Berg case? No? Okay. Let's move on to the next case, this Sommer versus Kridel, a very Jersey case indeed. This case involves something that you study in contracts, which is the duty to mitigate damages. And when must a landlord take specific steps to ensure that he's not putting the tenant in a worse off position than he should be? This is a flip side of unjust enrichment. If you think of them, it's basically the same thing, saying you can't charge a rent when you could get from someone else who actually uses the apartment. Right. So, Brenda, you want to tell us the facts here in Summers?
So the tenant and the landlord for 2 years.
Good.
So we after the tenant payment of it, it was the rent for the first month.
Good.
Deposit. So then before he moved in, or he never moved in, he sent a letter to him.
Yeah, it's really sad what happened. Aww. Aww. And then, but the important part, why did the plans change? Who was supposed to be paying the rent? Mommy and daddy, right? Yeah. So the sad, right? You know, he just got out of the army. He's going to law school. He's supposed to get married, and the engagement broke off. And by the way, his mother and father-in-law are no longer willing to pay for his rent. So it's sad. So he says, I hope you have understanding and compassion, and you can keep the first 2 months rent already paid, but release me. Brenda, did the landlord in New Jersey have understanding and compassion? No. Exactly. Yeah, it's a Jersey thing. There's no understanding and compassion in the Garden State. It's whatever. I'm from Staten Island, I can say this. This is actually the building. This is actually the Pierre. And I checked. It's in Hackensack, which is actually, you may have never heard of it. It's a fairly vibrant area, not too far from the ferries that go from New Jersey to Manhattan. And a one-bedroom apartment in the Pierre now costs about $1,900 a month. That's not a lot. I know. It's a blessing I live in Houston. It's affordable, but I mean, I paid that much for an apartment in Arlington for one bedroom, and this was like 6 years ago. And there's the goal. There actually used to be a YouTube video describing apartments. They took the video down. I just realized it this morning. But they had like pictures of the inside, so unfortunately that you don't get to see. But Google Street View they can't hide from. The unblinking eye of Google Street View. This was actually my first article I ever wrote ever. I wrote it as a paper after my 1L year on Google Street View. It had just been announced. I wrote about privacy and stuff, and it still gets cited every now and then. But yeah, it's Google Street View sees everything. All right, so the landlord never replies to his plea, his compassion, and okay. So then what happened? So the tenant was expected to move in. Erica, the guy never moves in. What happens then to the apartment for the next, I don't know, like year? No one moves in. Okay. Now, why does no one move into that unit? No, the unit was empty. Oh, you mean legally occupied? Right. So legally speaking, the tenant, and there's no talk of the fiance. Unclear if the fiance's name was in the lease. I don't know why. I always wonder about that, but maybe her name never, whatever. So legally, the tenant's name was on the lease, right? Did the landlord ever make any effort to rent that unit to someone else, perhaps? Right. No. But I'm talking in that long period beforehand. Okay. Now, Julia, did anyone express an interest in that specific unit? Okay. How'd that go down? What happened there?
They expressed interest in the landlord.
Okay, so now, Julia, I want you to put yourself in the shoes of the landlord, right? Why do you think he wasn't interested in giving that person that apartment? And who else?
And
New guy. He wants to double dip. Think about it. This person, whoever this person was, wanted to move into this building. He wanted to live in this building for sure. So the landlord has a choice. He can say, okay, you know what? You can live in this apartment and pay me one rent, or I can keep this rent open with the other guy and move you in over there. So he was trying to collect two rents simultaneously. I mean, this is in contrast what you would almost certainly refer to as unjust enrichment or something to that effect. Okay. Ultimately, he did rent the apartment out, but that was after quite some time. So the apartment was empty for a number of months, and finally he got a new tenant. Okay. So, Veronica, it seems that the landlord didn't have a very good lawyer because he filed a number of different suits, which he kept amending. Everyone know what that means when you amend your complaint? That means you screwed up the first time, and you're trying to alter it to bring the correct cause of action or seek the correct damages. So, Veronica, what were the various suits this guy brought? That's okay. He had a couple different lawsuits. His lawyer probably maybe didn't go to the same school as the plaintiff or defendant, but You have it? I'll come back to jail. What were the various suits that were brought?
I believe that the first suit was counting the whole time that
Good.
we
Yeah.
waited, and then didn't consider the deposit that's been
Good.
given.
Good, right? So the first one was the entirety of the lease, right? Even though he had paid a couple months rent, and even though someone actually came in towards the end. Okay, then Joe, what were the later suits that were brought? What was the final one, the one he actually settled on at the very end, the last suit? What was he actually seeking? Let me ask the question this way. How many months was actually the tenant on the hook for here?
That amount of the lease.
Well, the entire lease? Yeah, okay. Redeemed yourself. Yeah. He was basically suing for the period the apartment was empty, minus the rent he paid in the deposit, right? And he did not include when he actually relet the apartment. So there was a specific period of rent that was, the specific months when the apartment was empty. So basically from May of 72 through September of 73. So we're talking, was it about a year and a half, give or take. Everyone get what he was actually suing for. Okay. So what did the trial court do there, Daniel? How did the trial court resolve this? Okay, what did they say? Very good. And this language of justice and fair dealing, this is ripped right out of your contracts book, right? Now finish it up, Daniel. What did the Court of Appeals do? Why did the Court of Appeals reverse? On what basis did the Court of Appeals reverse? Where did they get that from? What did the Court of Appeals rely on to?
It said that the trial court release had been drawn to the civil law.
Then, okay, good. And how do we know what the settled law of the state is? Josh?
Is this Joyce v. Bauman?
Yeah, which court decided that?
This prior precedent of this appellate court.
It was actually what's it called, the New Jersey Court of Errors and Correction. It was actually basically the New Jersey Supreme Court, right? So there was a binding Supreme Court decision from New Jersey. It wasn't called the Supreme Court, but it was basically like the highest court. There was a binding precedent from the top court in the state that there was no duty to mitigate. Josh, did the trial court just ignore that?
I suppose essentially they decided they kind of knew the policy.
The trend, right? So it was the trend. So yeah, basically the trial court ignored New Jersey law. Whatever. The intermediate court, shockingly, actually applied New Jersey law. But because we have a case from New Jersey, Josh, what's the court going to do here? Reverse the common law. I mean, one and the same, but here they reverse it. If you know nothing else in law school, if it's a New Jersey or California case, they're about to reverse the common law without fail. I mean, I think in every single case in the entire book, that's the rule. There's actually a companion case. Madison, what's a companion case? Have you ever heard that phrase?
I guess it's just a case that is very similar.
Exactly. So very often, the Supreme Court of the United States or the Supreme Court of a state will bring two cases or three cases at once presenting the exact same issue, right? Why? Resolve them all at once. They all present the more or less same issue. And the facts in the other case were pretty much the same. You had a landlord who let an apartment stay empty and probably didn't exercise any due diligence to fill the apartment, although the record there wasn't clear if anyone wanted it. Okay, so Madison, walk me through the court's analysis, please, of how they go about determining that there's a landlord has a duty to mitigate in this situation.
So, following the increasing trend.
The trend. Okay, I'll pause a second. You notice a trend, right? In these cases, they always say there's a trend. The law is moving in this direction. We had this with the airplane hangar case from the other day, right? The law is moving in this direction, right? This is a very common technique that judges use to advance the law. It's not. I'm not making this up, but look what all these other courts are doing. And dare I say, I'm teaching a Berg this afternoon on one of the common tropes in constitutional laws. Oh, look at what these states are doing. Look what everyone else is doing. That's moving the law forward. If you want to see a connection between common law doctrine and constitutional doctrine, this is perhaps one linkage. Madison, sorry. Oh, speaking of Constitution, Madison, I'm sorry to interrupt, but you may proceed.
So going with this trend, they started
Good.
And under the contract, or application of contract, the doctrine of mitigation of damages came about, and back to the justice and fair dealings, they felt like if the landlord fails to mitigate damages, basically use his best effort to get rent and not screw over his tenants.
Good. Yeah.
Has the opportunity that maybe relief.
Very good. So what's interesting here, I want you to think about this in a couple levels, right? Rachel, what triggers the landlord's duty to mitigate? What triggers the landlord's duty to mitigate?
The surrender by the tenant.
Surrender, or what would generally call the surrender in this case?
Abandonment.
Specifically with respect to the lease, what happens?
Termination.
What do you do to a lease when you break it? What do you call that? Is that word? Begins with a B.
Breach.
Thank you, Maggie. A little help from the peanut gallery, right? What triggers a landlord's duty to mitigate is the breach. And just for me to think about this, right? The tenant screwed up, right? The tenant screwed up. And usually in the law, when you screw up, you bear the costs. What the court says here is the opposite. When the tenant screws up, the landlord now has a new duty, a new burden. What the court does here is actually shift the burden from the party at fault, the breaching party, to the party who did nothing wrong, which was the landlord. Right? And this duty to mitigate, we'll get to there in a minute exactly how you go about doing this, but it's a serious duty. And if the court finds that you did not exercise enough diligence, guess what? You're on the hook. So you have this tenant, this beat-neck tenant not paying his rent, and then maybe a court decides you didn't do enough to relet the apartment. Guess what? You're out of luck. So this is a very, I mean, it seems fairness, right? But it's very much different than traditional property rules because you're putting a burden on the non-breaching party as a matter of basic fairness. I mean, in this case, we can say fairness, the landlord screwed up. He let the apartment sit empty for 15 months. People wanted it. He said no. So yeah, in this case, the landlord probably screwed up. But you can imagine a case at the margins where the landlord, advertised it and didn't really make a push for it. And the court says, you know what, you didn't make enough efforts. You could have, hustled, and you could have told some other tenants to go there and, go see this apartment. Maybe someone wanted the apartment with a window facing the dumpster in New Jersey, right? Whatever. But people find property very unique. And the fact of the matter is the tenant gets off scot-free, right? Here, the tenant, all he loses is the deposit. He doesn't have to pay anything else. Even if the apartment remains empty, if there's a failure to mitigate. Okay? Okay. Yes, Hunter.
If the situation had been that the apartment sat empty for, say, 2 months, and the landlord's trying to get somebody to, he's actually doing this diligence, trying to mitigate losses, wouldn't he still be able to get the 2 months in the interim when he's trying to get that apartment?
Good luck collecting it. Good luck collecting it. Right, so that's the other issue which is not clear. The reason why landlords take a security deposit is that this is the only way they can get money. If he actually has to go and then try and collect the rent from the deadbeat tenant, good luck with that. Right, the dude already said, I can't afford to pay this. I suppose you can send a collection agency after him, but he's a law student. He has no money, so it would be a waste of your time. Once he's out of the apartment, the landlord loses all the leverage to ever collect that money. Especially if it's a law student. There's no way the guy's paying up. Although apparently in this case, he went on to have a successful legal career and won a boatload of money over his breach. I mean, I want you to just think about this for a second, right? He screwed up. I mean, he had an unfortunate, the wedding didn't happen, whatever, right? But the tenant screwed up here. And then he made up a lot of money off of this case. You can say, what a smart lawyer, right? What a smart law student. But this sort of holding is one of the reasons why the apartments in this building cost $1,900 a month. Because the landlord knows, well, if someone doesn't pay their rent, I'm going to have to get the money from somewhere else. I see. Everything rises costs. So, Fanny, what does the court say of how do we determine if, in fact, a landlord has made reasonable efforts to relet the apartment? What factors should the court look at to make that determination? Very good, very good. All exactly our reason. You effectively have to show the landlord made an effort in good faith to sell the unit. And if you think about this in terms of fiduciary, right? This effectively makes the landlord a fiduciary of the tenant. The landlords must act in good faith to let out the apartment that the tenant breached. So this is a radical shift. You don't think much in the law about burdens, but you really should. Because generally speaking, when the court assigns a burden to a party, here are the burdens for the landlord, that means the landlord loses. Almost always the court, once they put a burden, that means the party loses. Why? You say, well, he made efforts to rent the apartment, but they weren't reasonable. They weren't enough, right? He didn't actually go out of his way. He wasn't really trying. He was trying to double dip. And then even if, say, the landlord tried and didn't do a good job, the court comes back years later and says, you know what, you got to pay up. You can't do this. And then what happens? You have to end up actually paying more money to the tenant, right? The tenant can actually profit from this. This is the notes after the case, right? Imagine this, right? Imagine what this happens. Let's just say, make it easy. The tenant was renting the apartment for $100 a month. Okay, $100 a month. He had a 1-year lease. Guy never shows up. A new tenant comes in and pays $200 a month. Wait a minute. The landlord has a duty to mitigate, but now he's unjustly enriching himself. I swear, courts have actually held that the tenant gets the excess. That if in that given 1 year, the new tenant pays $200 a month, the landlord must pay the tenant $100 a month difference, so as there's no unjust enrichment. The idea is to put the landlord in the same place he would have been had the breach never occurred. Sarah?
Now, can the landlord avoid that by saying, well, we mutually terminated our agreement?
But this is only when there's a conflict, right?
I got you.
But what happened, I'll ask a different question, right? What if the initial tenant was supposed to pay $100 and the new guy only pays $50 a month rent? In theory, at least, the landlord can go after the tenant for $50 difference. Good luck with that. They're not going to pay. But if the rent is actually greater, you actually have a claim for unjust enrichment if he keeps the difference. So it's a really radical understanding of the law when you actually work through the implications of what applying a duty to mitigate means in this sort of residential area. Everyone with me so far? Yeah, Jessica.
I am with you, but it just seems to be such a overly protective, trend, because I understand. I mean, you have the property interest, and that's why perhaps it's like if you are able to collect a higher rent, the tenant consider that may have the right or not. But in contracts, if you have that apartment building and the obligation to mitigate damages, you also have the concept of, if I'm a dealer, I have all these other opportunities to actually sell or whatever, and then it's not taken as, okay, automatically the amount of money is when I go to repair whatever breach the tenant or the
right. It assumes a very narrow view of what a landlord actually does. Right? It makes it seem like all the landlords focus on is just one tenant. Whereas an entire building and lots of units to think about. And he may not particularly care about this unit. Maybe he just didn't get around to selling it. But now, because of that, he can't collect rent from the tenant. I mean, it's a really, it sounds really fair at first blush, but when you work the implications, it makes being a landlord a very difficult job, especially in New Jersey. Yeah.
I guess I'm just wondering about the logic of actually holding the tenant for the entire, essentially trying to hold them for the entire value of the lease. Because if they're already a deadbeat and they can't pay, say, 2 months difference between litigate, why do you expect to get 2 years of a lease out of them instead? I mean, I guess I'm not understanding why try and hold a deadbeat?
Oh, I see what you're saying.
Damage,
right. Okay, I see your question. So what Hunter's asking is, if the dude couldn't pay up the 2 months now, Why bother going to court to try and collect 2 years, right? Is that basically your question? Anyone want to take a step? I have an answer, I think, but Sarah, you want to take a step?
He knew he was a law student.
Oh.
But he's gonna have money later.
Okay, so that's actually more or less what I was thinking, right? You get a judgment against someone, you don't have to collect it right away. You could just collect it in 5 years. You can give it to a collection agency in a few years later. He knew he was a law student. It was right there in the letter, right? So he's like, okay, let this guy work for a few years and I'll collect it. And plus interest, by the way, because interest accrues on judgments when they're not being paid, and high rate of interest.
It just seems interesting because that was the same logic used to talk about why you wouldn't see the 2 months difference when you're trying to mitigate. Like it's the same concept.
Yeah, for the most part, look, I mean, for the most part, I'll get you in a second. For the most part, this issue doesn't arise because if a landlord knows a tenant can't pay, he's not going to waste his time going to court, right? He's already at the unit, whatever. But I think the reason why he left it empty in this case, particular to these facts, was because of the guy's future income. Usually, once the guy vacates, it's like, all right, whatever, let me rent it to someone else. You're not going to risk getting 0 rent when you can at least get 1 rent from a new tenant. But here, he thought he could double dip.
Could you get any incidental or consequential damages? For example, if you had to hire a realtor
You're talking about the landlord?
Yeah.
I suppose the landlord could deduct from the amount owed whatever incidental damages from hiring a realtor. I think the court would probably allow that, which would make sense. I mean, if you're trying to rent an apartment and this is before the internet, you need to hire a realtor to help with that. So I guess those fees can be offset. All right, other questions? In any event, the duty to mitigate has been adopted by Texas, I think 42 states. So it basically applies everywhere. So this imposes on the landlord the burden of taking various reasonable steps to re-let an apartment and preventing the sort of unjust enrichment. Yes, Hunter.
Where's the burden for proof of mitigation in Texas?
It-
Talk about it's either on the plaintiff or on the defendant.
You know, I'm not sure. I can look it up later. I'm not sure actually. But if I had to guess, let me ask you this question, Hunter, this way. What sense would it make to put the burden of proof on the plaintiff? How would the tenant know whether or not a reasonable effort was made? Right? I think the only party who's in a position to know is a party who is actually there. The tenant's gone. He never was in the building, right? The landlord would have to testify saying, here, look, I put this commercial, this advertisement, I showed it to this many people. It'd be I don't know how the burden would even work by putting on the tenant, but again, that's the way it's structured. So if I had to guess, I think it's a reasonable guess, it's on the landlord. But it's yeah, but I don't know. I mean, putting the burden on the plaintiff doesn't. It really doesn't. So maybe Texas is that one. I don't know. Look it up later. I'll look up. I'm not sure. I'll get back to you. Anything else? All right. Well, hopefully I'll see you at 11 at the free speech talk. If not, have a nice weekend. I'll see you all next week. Yes, sir.
Synthetic nail set.
Yeah.
In my class,
Thank you. Do you think those are tenants?
Yes.
I mean.